Thank you, Wanda. That was very insightful, and our next speaker is Jim Howie of Howie, Sachs and Howie.
Henry.
I'm engaged to the Henry, and I call him Howie. At least I didn't call him Jim Henry, which I've been known to do. Anyway, accessing funding for medical rehabilitation benefits. Let me tell you a little bit about Jim. He's a founding partner of Howie, Sachs and Henry. He was admitted to the bar in 1980. He has been a member of and director of the Advocate Society, member of Council of the Medical Legal Society of Toronto, is a member of OTLA, the American Association for Justice. He's been the past president of the Toronto Lawyers Association and the former director of the Brain Injury Association of Toronto. He, for the past, or over the past 10 years, has been listed in the Canadian Legal Expert Directory as a leading practitioner in personal injury law and has been repeatedly named to the National Post list of the best lawyers in Canada in personal injury. Jim's practice is devoted to litigation, principally in areas of personal injury litigation, insurance claims, and medical malpractice on behalf of victims. Jim is going to be talking about accessing funding for the medical rehabilitation needs of our clients, but he's also going to deal with the dispute resolution process, means of dealing with obtaining outside funding, outside of the accident benefits, requesting advance payments from a defense counsel and tort claims, and dealing with tort litigation loans, which are a big topic right now. So please welcome Jim Howie.
Thanks, Renee. It is Renee, right? Yeah. Okay. I want to start off by suggesting to everybody that you may want to look online at the paper that I did along with Melissa Miller, one of our associates. It's going to be much better to read that paper than to listen to this talk. No, that's just the outline. There's actually a longer paper. Gives you a little more detail. The conference, of course, today, WTF, well, we all know what that means. I, of course, will deal with the F word, funding. And so I want to talk to you about some of the challenges that we all face these days. Clients in particular face challenges with accessing funding for treatment. Treatment is something that I think most everybody here in the room understands that victims of accidents need. And those challenges in effect get passed along to lawyers that look after them or advocates that look after them, and also passed on to treatment providers. The challenges are lack of funding. And there's a big impact on the victims, as we know, from lack of treatment. Somebody with serious injuries who cannot access enough money to pay for necessary physiotherapy, occupational therapy, attendant care, any type of work that they need in order to help them sustain or get a better recovery, and the lack of that funding is just a very sad situation for all of us, I think. One of the problems that is dealt with these days is, or arises when somebody is under the MIG. And I know you heard a little earlier from Jamie about the issues under the MIG and how to get out from the MIG. But obviously, if you can move out of the MIG into the next category of funding and move from having $3,500 available to have $50,000 available for your treatment area, that's a big deal. How do you get there? Honestly, I think the most and best way to do that is with a cooperative venture on part of the treatment people and the medical people working on the victim and the counsel or advocate who's representing them. The effort is, of course, to persuade the insurance adjuster or claims examiner, whether they be Wanda or somebody else, that the person has been improperly put in the wrong category. No, I won't. Sorry. So the issues under that cooperative heading, of course, is to try to persuade the adjuster to move the victim into the next category. What happens if you don't? Well, you've heard about some methods of that, I believe, from Jamie this morning. There's a further problem, and that comes up in the more serious injured victims, where people have the insurer is prepared to agree they're not in the MIG, they're in the next category, but will not agree that the victim is in the catastrophic category. And the most frequent situation that we run into, at least in our office, involves typically someone with a head injury. If the head injury is serious enough, but they're not seen fast enough by an ambulance person or a medical person to assess them with a GCS of 9 or less, then you have the immediately following problem that over the next 2 years, they're going to get access to $50,000 of med rehab. How do we deal with that problem? In fact, when I thought about it, and I was thinking about it over the last few days, it really is a very odd problem, because when the government changed the legislation in September 2010 to drop the access of that level of coverage from $100,000 to $50,000, they also added in the issue that you can also or must also count dollars spent for medical assessments in the $50,000. Now, if you think about the lawyer's job, you get the victim, you're trying to help them access treatment, you're trying to help them because you know that treatment will get them better or at least improve their chances for a good outcome. You want to get them into the catastrophic area. You want to get them into that higher level of designation. Well, if you start spending money on medical reports to prove that they're in the catastrophic area, you're now cutting down on the $50,000 available for treatment. It's a horrible conundrum. How do you deal with that? One way that we try to deal with it in our office works if you have a good tort claim going at the same time, is to access those medical reports that you need in the tort case and use them in the AB case. Make the disbursement payments for the medical reports part of the expenses that the lawyer bears, in effect, hopefully to pass on to the defendant insurer, and don't cut into the $50,000 limit by doing that with the reports cost. In more cases, I think the far better way to deal with it is to try to make agreements with people on the other side of the case. You make agreements or try to make agreements with insurers or their representatives, if they have legal counsel, to advance funds to be helped for treatment or to be used for treatment. For example, in a case where, let's say we take that same head injured victim, they're not catastrophic yet. The ambulance didn't arrive for 20 minutes post-accident. Only the witnesses saw the person unconscious for a period of time, and by the time the ambulance arrived, not GCS eligible for a catastrophic determination. But you know, meeting the victim and seeing their treatment, talking to their medical people, that they don't have a good chance of recovering so that they will still be catastrophic in 2 years when we can assess them to prove that they're catastrophic. How are you going to fund their treatment that they need? Clearly, it's going to cost more than $50,000 over the first 2 years. In some cases, we've been able to approach the insurer and say, look, you don't want to agree that the person is catastrophic yet. We think they're going to be catastrophic, and here's the medical documentation to show that. How about you agree to advance funds, even though your $50,000 has been spent, on the basis that the victim will sign something, or the family or the lawyer will sign something agreeing to pay the money back out of tort funds if the person doesn't get found to be catastrophic. It's a bit of a win situation for the insurer, because you might ask yourself, why would someone like Wanda want to fund that? And the answer is, if it turns out that the victim is catastrophic and they haven't done anything other than pay their minimums, they may be in a position where we will be seeking bad faith damages or special awards against them through the FSCO process for failing to deal with the person appropriately when it became obvious later down the road that they were catastrophic. If the insurer has a reasonable prospect of knowing that they're going to get repaid, even if the victim isn't found to be catastrophic because of being repaid out of tort proceeds, then they may be in a position to advance more funds. It's a sticky problem, because you still, as the lawyer, have to be sure that the client understands, appreciates, gets the drift of the fact that out of their tort proceeds, some of their money is going to treatment. But I always find if I spend some time with them and explain that their chances of recovery are significantly improved with more treatment, it's money well spent. And usually that solves all of that problem. What about advance payments? Many times in significant cases, tort insurers and their counsel are creative enough in the long picture, the big picture down the road, to understand that the victim's going to run out of money under the AB system, and to understand that if you advance more money for treatment now rather than 2 years from now or 3 years from now when the case finishes, the chances for a good outcome on the part of the victim improve. And many times we will approach tort defendants or their counsel, either the adjuster or their counsel, and say, how about advancing some funds? How about another $50,000 to be used for treatment? How about we don't give the money to the victim or their family, we put it in our trust account, and when they submit bills to us that are appropriate, we will pay those bills and we will account by paperwork to the tort defendant showing where the money's going. A lot of times when tort defendants, their lawyers or insurance companies, are looking at their overall exposure in a case, 6 months, 9 months after the accident, the victim's still not back at work. Well, they're facing a lost income claim that's going to grow and grow and grow if this person never gets back to work. Offering them the option that if you advance some monies for treatment, the victim has a better chance of recovering, has a better chance of going back to work, you have a better chance of reducing or eliminating your exposure to a loss of income claim. Unless they're dopey, they're going to get this. So again, that's a method that I believe works, and if there's any sophistication on the part of the people who are defending, you get an advantage that way. There are all sorts of other potential avenues for getting treatment. What if you try all these different avenues, none of them work? Well, strangely enough, one of the avenues that can work is clients do have money, some of them. Some of them are actually rich. I know it's weird, but the odd victim actually has lots of money. We actually act for a few in our office of people who have way more money than me or anybody sitting up here. So they can access their own money. And I think a lot of lawyers in particular, and maybe even some treatment providers, don't think of that. If you're worried about getting paid yourself, well, ask for the money. Maybe they've got it. I've found, or we've found, particularly with wealthy people, where the insurers refuse to fund certain things, refuse to make advance payments, we can put a lot of extra pressure on them, talking about bad faith issues, and you're failing to help this person get a good recovery, and the insurer or their counsel should start to worry a little bit. But if the family has lots of money, they shouldn't care. It might be the best investment they ever make, is to let the insurer stay in bad faith and just continue to fund treatment themselves. Clients should be, and we've often encouraged them to consider withdrawals from RRSPs or tax-free savings accounts, remortgaging their houses. There's avenues of that type. There's access of policies at work. Most of us that work in offices that have some kind of a health policy, often when we examine the health policies that people have at their work, there's all sorts of funny little terms in there that often cover some of the costs of what they need arising out of a car accident. So it's often good to examine that and see what kind of coverage you can obtain for the person, not just the accident benefit insurer. Technically, that's the area of first recovery anyway, is supposed to be the victim's other policies before the accident benefits. Most of you that are in the treatment field know, of course, that there are other avenues available to the victims in public funding areas. For example, ODSP, OHIP at its most basic, obviously, CPP, Veterans Affairs, War Amps, March of Dimes. A lot of these organizations can step in and provide some services or some funding for some things that victims often need. One other option I want to talk about for a few minutes is the option with respect to the treatment providers themselves. And many of you I know in this room are in that area, do this work for a living. Many of you have spoken to me or some of my partners when these changes were coming prior to September 2010 and said, what the heck are we going to do? I mean, we need to get paid. If you run a clinic, you have people that work for you. We need to get some money coming in so we can pay salaries. We have overheads to deal with. How are we going to deal with that?